good morning, good evening, good afternoon, depending on where you're watching from. I am taking a break. I am 2 hours and 14 minutes into last night's. That wasn't a Coded Friends. Who was that? That's an NTFG stream. It's not too fucking good. Anyway, I am told that I need to make sure to tell you guys, because I am a money sucking loser, just like everybody else out there. Channel, there is copy link address. Make sure that everybody goes to, not that. How do I get that? My go to my well, let's see if we could do this. https://tinyurl.com/y7 JKNBJG. Let's see if that works. Okay, so make sure that you go to that link. That takes you to my G-String account. Coded has reminded me that I have not pushed my G-String account for a while. It's expensive to buy these Pacer documents, so make sure you check out my G-String account. I can't wait for someone to call me out on that. Tell me that I'm a money-grubbing fool. All right, so what are we looking at today? Well, we're starting off with a little bit of Springer versus the 7th Judicial District Court. And oh, hey, someone donated. Thank you, Neil McDonald, for donating to my G-String account. Bow chicka wow wow to you too. But what you'll see here is that defendant Jason Jones and Mercedes Murphy, 7th Judicial District Court, Shannon Murdoch, Susan Rosengal, they are all now represented by, it looks like the Garcia Law Group. You've got Brian Garcia, Jay Delphin, and Rodney Gabaldon. I'm probably saying that wrong. So anyway, there has been some change. And then as far as what's going on, there was an order for a briefing schedule, and that's been vacated now that the defendants have appeared. So just to be perfectly honest with you, I haven't seen, and nowhere in Pacer did it show, a actual answer by the defendants. But they have appeared. There was a notice of appearance, and that's all we got. It's not an answer. It's not a motion. It's an appearance. So I don't know what's going to go on there, but we will figure it out from there. Now, what are we looking at here? What we're looking at here is I don't know if you can see my cursor here, but it's doing this swirly thing. Now, this is the second computer. I have attempted to buy the complaint for this particular case number. This particular case number is for Turner versus Richard, which isn't Richard, it's Richard. Schiff, I love you. I don't know what that means. Do we have someone up here named Schiff? Oh, you mean Shiz, I guess. I don't think Shiz comes to my streams anymore. I think I might have upset her, rocked the boat a tad bit. So anyway, this is Philip Turner. You may know him. You may know him. You may even love him. And he, along with James White, have sued the city of Corrigan. I don't know if any of you remember, but the city of Corrigan had, for a very short period of time, Corrigan. Oops, I'm going to go back here. I'll go here. Corrigan. I want to share this tab instead. So this is this video right here. Philip Turner, aka Batosai, doesn't understand Turner v. Driver. I still, to this day, what aren't I young and adorable then? Lord have mercy. Look at that face. Look at that cherubic face. Oh, so young, so innocent, so naive. I still get sort by newest first. 8 hours ago, 2 days ago, I still get comments on this, and everybody says you don't know what you're doing. You don't know what you're talking about. Well, let's go through some things. Let's go through some things. This is Turner v. Driver. You may recognize it. This is the appeal. So what happened is Turner sued Driver and the other guys, and then he lost at the district court. He appealed to the appellate court, the United States Court of Appeals, Fifth Circuit. They found that, in fact, there was qualified immunity. However, they went on to say, so he lost. He lost. I just want to be clear that he lost. So all three officers are entitled to qualified immunity on Turner's First Amendment claim. There are some other things that he could have proceeded forward on, but as far as the First Amendment claim, he lost. Happy Friday. So they went on to talk about whether the right is clearly established henceforth. So it was not established, yada, yada. So they start talking about it. Now, we're going to look at some things. Because the issue continues to arise in the qualified immunity context, we now proceed to determine it for the future. And you'll see in here, the Fifth Circuit apparently has not explicitly noted right to film police or outlined the contours of such a right. However, the First Amendment protects a private citizen's right to assemble in a public forum, receive information on a matter of public concern, such as police officers performing their official duties, and record that information for the purpose of conveying that information. Quoting, it was this one right here, quoting this right here. So talking about public forum there, and you're going to say, but wait, that's in a footnote. That's dicta. Dicta. So they say, we agree with every circuit that has ruled on this question. Each has concluded the First Amendment protects the right to record the police. Now, who do they cite to that? They cite Alvarez, which is filming in a traditional public forum. Glick, filming in a traditional public forum. Smith was, I believe, talking about filming a public meeting. So Smith is a little odd one out. And then Fordyce basically just says that there is a right to film police. It doesn't really talk a whole lot about it. Oh, shit. You can't see what I'm seeing. God damn it. Could you guys stop fixating on the gorgeous beardless man in front of you and tell me that I'm on the wrong page? Have you no shame? Put your penises away, or not, whatever. So we were looking at these right here. Fordyce was in a traditional public forum. It didn't really go into a lot of analysis. It just talks about a generalized right to film police. But Alvarez was a traditional public forum. Glick was a traditional public forum. Smith was filming City Hall. So Smith is kind of the odd man out. But we'll continue to beat this down. Go back to the pick. I wasn't finished yet. You know what? You're just a baiter then. A masturbator would have been done at least 2 or 3 times by now. So, as the First Circuit explained, the filming of government officials engaged in their duties in a public place, including police officers performing their responsibilities, fits comfortably within basic First Amendment principles. And they cite down to 47. 47 is Glick. Glick, again, was filming in a traditional public forum. This right, however, is, quote, not without limitations. It's going to 48. Again, we're talking about Glick. Like all speech, and this is 49, this is Consul which discusses the history of time, place, and manner restrictions. which apply to traditional public forums, filming the police may be subject to reasonable time, place, and manner restrictions. And then this is, again, going back to Glick. Importantly, an individual's exercise of her First Amendment right to film police activity carried out in public, shorthand version for in a traditional public forum, necessarily remains unfettered unless and until a reasonable restriction is imposed or in place. And it was citing DeGarricky, which was filming in a traditional public forum. Actually, was Garricky in a traditional public forum? Garricky was on the side of a highway, I think. In this case, however, we need not decide which specific time, place, and manner restrictions would be reasonable. That's 51. Again, we're talking about Glick. Nonetheless, we note that when police departments or officers adopt time, place, and manner restrictions, those restrictions must be narrowly tailored to serve a significant government interest. The narrowly tailored part should inform you that they're talking about a traditional public forum. Because if it is a content-based restriction, then it is a strict scrutiny standard if it deals with a traditional public forum. You can have a reasonable time, place, and manner restriction as long in a traditional public forum, which would be subject to a lower scrutiny and intermediate scrutiny, but then it has to be narrowly tailored to serve a significant government interest. And then this is talking about McCullen versus Coakley, dealing with a traditional public forum, quoting Ward versus Rock against racism, again dealing with a traditional public forum. That said, to be constitutionally permissible, a time, place, and manner restriction need not be the least restrictive or least intrusive means of serving the government interest. That's, again, talking about McCullen versus Coakley. So what it is telling us, this is the reasonable time, place, and manner test that you use in a traditional public forum. The McConnell versus Coakley one McCullen versus Coakley. This is a restriction on being within 35 feet or yards of abortion providers, and essentially to deter people from going to get an abortion. Ward versus Rock against racism. This is where it was restrictions on the volume of concerts, the volume of public concerts in Central Park, New York City Central Park. So this is, again, another traditional public forum. So how do you know what a traditional public forum is? Well, let's go to this one. By its very terms, the act restricts access to public ways and sidewalks, places that have traditionally been open for speech activities, and the court has accordingly labeled traditional public forums. Traditional public forums are places where you would think of where you could put a soapbox up and grab a bullhorn and yell at people about the end is coming, or repent, or whatever message you have to share. That's a traditional public forum. A police station is not a traditional public forum. Now, I did look at the Corrigan, Texas ordinance. I did an analysis of it. I do not think the Corrigan, Texas ordinance, which was subsequently repealed by the city of Corrigan, it was never challenged in court, but they voluntarily pulled it down. Now, they didn't pull it down because they're scared of Turner. They didn't do it because of that. I believe that because attention was drawn to it, a lawyer looked at it, not Philip Turner, who's not a lawyer. He doesn't pretend to be a lawyer, and he doesn't fucking understand that inside of a police station, in the lobby of a police station, is completely different than being on a sidewalk. Remember, Turner v. Driver, Turner was on a sidewalk. He was outside of a police station on a public sidewalk that was abutting a street. It wasn't an internal one. Who's that dipshit? What is that guy's name? What is his name? I need to remember that fucker's name. Stout, I think. Let's see what we got here. Clear all. What circuit was Stout in? He is in. He's in Virginia, right? I want to say he's in Virginia. So we're going to look at. Wow, Virginia has 4, huh? Stout. What was the name of that one? It was. He was at a police station. Police station? Was it Mishu? Was it Mishu? Oh, you guys don't see this. Okay. Yes, I am going to join Coded Friend at NTFG-SFW Saturday evening. We will both be naked and touching each other. You won't be able to see us touching each other because Coded Friend never turns his camera on. He doesn't want to make us all jealous of his good looks. His boyish charm. So yes, I will be joining Coded Friend tomorrow. No, it'll be full hands on, buddy. Like you're gonna feel my cold hand sliding up your thigh, and other places because your wife's out of town. Nobody needs to know. Oh wait, I already blew it. 6 o'clock Pacific, which is my time, and not 9 o'clock Eastern, which is not my time. So this boom. Okay, so in this one, they were on Stout. The Legal Genius Stout was on an internal sidewalk. He was up by a gate, so they were actually up in the property. But as far as Turner v. Driver, he was actually on a just regular city sidewalk abutting a street. So once again, I just want to be very clear that that Turner v. Driver, I understand it, and it is a traditional public forum test. Now, you got to remember that the First Circuit has decided to take the right to film the police outside of the public forum analysis. But like, for example, the 10th Circuit with what's Donkey's name? Jaden? Someone help me with Donkey's name. It's like Jaden or something like that. Jaden, thank you, WTT. All right, so we're going to look up Jaden Kerr because he was out of... He was filming Kerr versus this... I'm going to show you this one instead. I believe it's going to be this one. Yes, and Control F, non-public forum. Defense argued the right to film could be restricted in a non-public forum. They say the jail property, including the adjacent curtilage, is a non-public forum. They aver this is consistent with the general First Amendment jurisprudence. In other words, the jail's property where the arrest occurred is traditional. The first issue is whether or not the jail is a traditional public forum. And the center is not the type of public forum in which the government must allow picketing and other forms of protest. Nothing in the Constitution requires them to grant access to it, etc. It's not a designated public forum. Just because the Boulder County owns the jail doesn't mean it's a traditional public forum. And I thought they addressed the right to film police. I thought they addressed that in this one, or was it a different one? One of these Colorado boys tried to sue for the right to film the police on non-public forum. I thought it was this one. And the 10th Circuit said it is a traditional public forum test. I thought the boom. Here you go. For example, so yeah, it is this one. So none of the cases, plaintiffs do not have a clearly established First Amendment right to film on jail properties and non-public forum. None of the cases cited by plaintiffs as purportedly showing a clearly established right to film involves a non-traditional public forum, whether a jail or otherwise. They all involve traditional public fora, like street, sidewalks, and similar public spaces. For example, Turner v. Driver, the plaintiff was filming a police station, quote, from a public sidewalk across the street from the station. So the 10th Circuit clearly believes that it is a traditional public forum test. Now, again, the First Circuit has taken it away from that, but we're talking Turner v. Driver. We're talking Fifth Circuit. Until the Fifth Circuit strips it away from being a traditional public forum test, it is only a traditional public forum test. It does not apply to police station lobbies. So there. So why are we talking about this? Because Philip Turner sued them for something, and I don't know exactly what it is because, again, I can't buy this goddamn thing on Pacer because, again, this stupid son of a bitch won't download for me. So if any of you geniuses out there can figure out how to get this thing downloaded, I would appreciate it because like I said, I tried it on 2 computers and I'm just not smart enough to figure it out. But what we do have is we have a motion to dismiss by the defendants. It was filed on July 28th, 2023. They've asked for extensions of time, and Turner still hasn't responded to it. But let's take us a little peeky poo at this one. So here's Philip Turner and James White versus the City of Corrigan. This is the defendants, 12B6. They're saying that there is going to be qualified immunity. The reason why it's qualified immunity is because Article 600, Chapter 8, Article 600 of the Corrigan City Ordinance was never adjudged to be unconstitutional. And until an ordinance is determined to be unconstitutional, police can't get, there's no stripping qualified immunity because it hasn't been clearly established that it's unconstitutional. So this is what it was. No video allowed in or around Corrigan Police Department. I think that's definitely vague. And also it's probably not narrowly tailored enough to allow a reasonable time, place, and manner restriction. Police doors will not be open to taking pictures or video inside the police vehicles. No videoing allowed through any windows. No pictures or videoing will be taken in the front of the building area where police vehicles are parked. And if I remember correctly in the video, these vehicles were parked just like basically right off the street. So like if you're walking down the side of the street, you would be walking, you basically have to like take a step to the left, I think, or a right. I feel like I'm starting to sing Rocky Horror Picture Show stuff. But basically these things are like right off the side of the road. Lobby area, I think this one would be a valid restriction, et cetera, et cetera. So they're saying that there is no determination that particular ordinance is unconstitutional, and so qualified immunity exists, and they didn't accurately or completely plead any Monell claims, so there is no Monell claim. So that's what they got there. It's not really, I'm not really able to talk in much detail about it, like the quality of the lawsuit, because I can't see the complaint. Merv is showing his age. Well, that's not a very nice thing to say, Denise. I'm 29 and beautiful. The next thing we're going to look at, I apologize for flipping through these so quick. This is in Decastro versus Wagner, and this is the response to plaintiff's second motion to reconsider. A motion for reconsideration is not specifically provided for, so it's a 59E motion. It is not recommended, it's discouraged. Rocky Horror Picture Show. How did you know that I used to perform in the Rocky Horror Picture Show? I'm lying, I didn't. Or am I? The motion is considered an extreme remedy. It should be used sparingly. So his points and authorities don't warrant reconsideration. So he presents 5 points and authorities to this court to consider. A, he's not required to deny defendant's assertions. B, social security number privacy. C, lower pleading standards. D, leave to amend. And E, excusable error. As explained below, he's merely attempting to re-argue his case because he disagrees with this court's August 3rd order. Yes, it's exactly what he's trying to do. Let's do the time warp again. Yes, probably that was the song I was thinking of. This court's order on August 3rd, 2023 held the plaintiff repeatedly failed to address the Lawrence County defendant's assertion that their omission from the first amended complaint functioned as a voluntary dismissal of the claims against them. The court noted the plaintiff referred, quote, generally to Chapman in the body of his amended complaint, but he nevertheless admits the allegations that were included in his original complaint. This serves as a further indication to the court that Decastro did indeed intend to discuss or dismiss his claims against the county defendants. Plaintiff claims, however, that, quote, this is false. That's the nope defense, by the way, because he, quote, only made one response to defendant's motion, and it was an opposition, but it didn't oppose anything. So just because you titled it as an opposition doesn't mean it's actually an opposition. However, the Lawrence County defendants questioned multiple times whether plaintiff's first amended complaint set forth claims against them. For example, their motion to dismiss the first amended complaint said that the amended complaint failed to name John Chapman, Jane Doe, and Lawrence County's defendants and failed to set forth any causes of action against them. In fact, in the motion to dismiss, the following argument was made regarding the omission of the Lawrence County defendants in the caption of claims against them. Yada, yada, blah, blah, blah. Plaintiff never addressed the issue in his response. Lawrence County defense replied in support of the motion to dismiss, also discussed whether the aforesaid defendants were still being sued because it was unclear whether the plaintiff's response in opposition was directed towards the Lawrence County defendants. The certificate of service did not set forth the response was mailed to Lawrence County defendants, but it did provide that the document was being mailed to counsel for the City of Ironton defendants. Moreover, the Lawrence County defendants reply no, the plaintiff's response failed to address any arguments set forth in their motion to dismiss. It's fucking weird. You can't just ignore them and make it go away. Additionally, defendants' response in opposition to plaintiff's motion for a protective order addressed the question of whether the first amended complaint asserted any claims against the Lawrence County defendants. Defendants' response provided that the amended complaint fails to name John Chapman, Jane Doe, and Lawrence County's defendants, and it fails to set forth any cause of action against the aforesaid defendant. The response noted that this issue, as set forth in the defendant's motion to dismiss, remains pending before the court, and as a result, it is unclear whether the cause of action set forth in the amended complaint are against Lawrence County defendants. Plaintiff filed a reply in support of his motion for a protective order, but failed to address whether his amended complaint asserted claims against the Lawrence County defendants. Thus, this court properly held that plaintiff, quote, repeatedly, end quote, failed to address the Lawrence County defendants' assertion that their omission from the amended complaint functioned as a voluntary dismissal of the claims against them. Since we have more people in here, make sure, as was pointed out to me by Coded, make sure that you donate to my G-String account. I've posted a link in the description. These Pacer filings are expensive. They severely eat into my G-String budget. Please donate to my G-String account. Thank you. All the money that goes into my G-String account will be used exclusively towards Pacer purchases. Exclusively. You have my word on that. Not one penny from my G-String account from the donations you made will be spent on anything other than Pacer purchases. Don't hit the like button. Hit that link. Donate to my G-String account, Denise. It's all about G-strings. Donate. Thank you, Pure Fetish. Thank you for donating. I see your donation. Thank you. I appreciate that. Plaintiff further claims that he, quote, learned that naming a government employee in their official capacity also named their employer and did not wish to name them twice. However, neither the caption nor the body of the first amended complaint names John Chapman, James Doe, and or Lawrence County's defendants or sets forth causes of action against them. Yes, please, WTT. I would love to get that. I probably won't go through it tonight. It's something like 42 pages. I would love to read it. But yes, if you can get me a copy of that, I would appreciate it. It'll be interesting to see what kind of claim they have, see if they have anything decent going on. Thank you, GMK. I appreciate the donation, buddy. You're good. You're a good person. Thank you, Denise. Thank you for the donation. I see that now. Thank you very much. I appreciate the donation. You guys are being way too kind. We're going to have so many Pacer purchases with all of your kind donations. I really do appreciate that. I really do. It means a lot to me that you guys care enough to donate. And the link, again, folks, if you haven't donated yet, the link is in chat, and there's a free gift. You know what? I'm a giving guy. So not only will I only use the money for Pacer subscriptions, but there's a free gift just for clicking on the link. You don't even have to donate. Just click on the link. Free gift. You can't lose. You literally can't lose. Thus, defendants maintained the plaintiff's first amendment complaint, which eliminated the defendants in the caption and the cause of action that were set forth in the original complaint, operated as a voluntary dismissal of the aforesaid defendants. Plaintiff claims that a double donation, thank you, Coded. Oof, thank you. I love a man with stick-to-itiveness. Plaintiff claims that he was not required to deny defendants' incorrect legal conclusions. Defendants never asserted, quote, incorrect legal conclusions. So you don't have to deny incorrect legal conclusions because we haven't asserted it. Is it? Let me double check. Thank you again, WTT. I will donate in your name to the G-String account. Perfect. Oh, thank you, sir. Thank you so much. All right. The man comes through. You know what? Say what you will about WTT. The man comes through. Comes through. Just yours, Jerry. And I really wish you'd stop sending them to me. I'm wearing out the scroll wheel on my mouse, zooming in on it. Again and again and again. The Lawrence County defense are not required to read between the lines and presuppose plaintiff's intentions regarding what claims he is asserting and the parties he is asserting claims against. You have to remember that the minimum pleading standard is to place the opposition on notice of what you're suing them over. Issues adverted to in a perfunctory manner, unaccompanied by some effort at developed argumentation, are deemed waived. It is not sufficient for a party to mention a possible argument in a most skeletal way, leaving the court to put flesh on its bones. Neither courts nor defendants are obligated to search through a plaintiff's complaint and its various supplements in order to glean a clear and succinct statement of each of the plaintiff's claims for relief. Rather, it is a plaintiff's responsibility, pro se or otherwise, to edit and organize his claims and supporting allegations into a manageable format. The Lawrence County defendants maintain the first amended complaint deliberately omitted the aforesaid defendants and the claims that were asserted against them in the original complaint. Very good argument. Social security number privacy. Plaintiff claims that whether a social security number is protected by a right to privacy, defendants do not allege they had any right or need for the information. However, whether the Lawrence County defendants had a, quote, right or need for that information, end quote, is immaterial. Plaintiff originally claimed that his Fourth Amendment rights were violated because Chapman asked for a social security number during the booking process at the Lawrence County Jail. Plaintiff claimed that, quote, Chapman knew or should have known that a person refusing to provide his social security number in order to complete the processing of an arrest is not in violation of any law. Plaintiff further alleged that, quote, it is a Fourth Amendment violation when compelling someone to do so under threat of punishment, end quote. Nonetheless, case law set forth in defendant's motion to dismiss the First Amendment complaint explains that the Constitution does not provide a right to privacy in one's social security number, and as a result, plaintiff's constitutional rights were not violated because he was required to provide his social security number. Accordingly, the plaintiff or the court properly granted the Lawrence County defendant's motion to dismiss. Lower pleading standards. This section revolves around plaintiff's arrest by the Ironton Police Department. And it just completely does not apply to the Lawrence County defendants. And then leave to amend. Plaintiff claims that when a motion to dismiss is granted, courts typically permit the losing party to amend. In an attempt to bolster his argument, plaintiff cites to Brown versus Matuzak to support his assertion that a district court should normally grant a pro se plaintiff leave to amend, where the plaintiff could possibly cure the pleading defense by pleading additional facts, even where the plaintiff has not requested a leave to amend. Brown held that the plaintiff, quote, did not ask for leave to amend, but at least 3 circuits have held that if a complaint is vulnerable to a motion to dismiss, a district court must first permit the plaintiff to file a curative amendment, even if the plaintiff does not seek leave to amend. However, plaintiff conveniently omits the fact that the Sixth Circuit Court of Appeals in Brown specifically held that, quote, there is currently no rule of law in this circuit that requires a district court sua sponte to give a pro se plaintiff leave to amend his complaint absent a request. And so generally, a district court does not abuse its discretion in failing to grant a party leave to amend where such leave is not sought. Therefore, to defendant's knowledge, there is no binding case law holding that a pro se plaintiff must be given permission to amend the complaint even when it is not properly requested when a motion to dismiss is granted. Moreover, plaintiff alleges that he, quote, requested leave to amend prior to dismissal at Opposition 39. However, plaintiff's, quote, request, end quote, is not a proper means of requesting leave to amend a complaint. This very issue was addressed in Whitley. You have to file a motion. You have to file a motion. You have to attach it to the motion. Similarly, the plaintiff's alleged request to file an amended complaint was merely a sentence set forth in his memorandum. The request stated as follows: if the underlying facts were lacking, which is all that is required of plaintiff at this pleading stage, he should be given leave to add them. However, plaintiff's request in his memorandum of opposition is not a proper motion. He also failed to provide a proposed amended pleading to this court to review, and as a result, the court has no basis to determine whether an amendment is warranted. He also ignores the fact the court did, in fact, permit him to file an amended complaint. It was the first amended complaint that he admitted the Lawrence County defendants in the caption and admitted the cause of action set forth against him that were contained in the original complaint. Accordingly, the plaintiff's argument that he should be given leave to amend his complaint for a second time is meritless. If he files a motion, if he actually follows the correct procedure, files a motion requesting it, attaches a copy of the proposed amended complaint, the court will probably accept and allow him to amend his complaint and set aside the dismissal. You know, Jeff, if you keep spilling my goddamn secrets, I'm going to ban you, bro. That is not cool. You're not supposed to tell everybody. You're not supposed to tell everybody of my love affair with a stripper named Pacer. That's between her, me, and the bartender, who apparently you must know. Asshole. Excusable error by plaintiff. Plaintiff claims that he, quote, expected to be able to amend his complaint at least a second time because, quote, errors of law or fact, errors of procedure or evidence, mistake or inadvertence, or surprise caused plaintiff to leave out allegations in his first amended complaint. God damn it. Now Coden's spilling the beans. Fine. You know what? Well, actually, no, because Pacer identifies as female and she has a very feminine penis. So don't judge, okay? I know you're transphobic. Don't judge, Coded. However, plaintiff fails to grasp the fact that he omitted John Chapman, Jane Doe, and Lawrence County, Ohio, from the first amended complaint when they were originally. So So funny story. Funny story. We're taking a little detour. This is a sit on Uncle John's lap, and he's going to tell you a story. I work with a trans man, female to male trans, and this trans man is gay, i.e., this trans man likes men. The reactions when people learn, like, it seems like they could wrap their head around trans man. Okay. They could probably wrap their head around gay man. Sure. But female to male, gay man blows people's fucking minds. Blows their fucking minds. And the weird thing is that like people are like they would be totally okay if he identified as a she still and was with men. No one would be batting an eye. But because he identifies as a he, it's like, you know, you can't triple stamp a double stamp. Like they're double stamping a triple stamp over here. It just blows their fucking minds. Second story. Long time ago, I had a buddy. We were in tabletop gaming, and he's like, hey, you know, let's have a game, and I can find a couple players. You know, we'll do it at your place, and I'll go to the game store. This is back in the day where we had game stores, and I'll go to the game store and I'll get a couple players, and then we can go game at your place. I'm like, okay, yeah, that's fine, let's go. So anyway, he calls me up. He's like, man, I got a couple players, and you know, let's do it. Let's game at your place on Saturday night. I'm like, okay, cool. So Saturday, he meets him at the game store, and he calls me up on the way over to my place. He's like, hey man, oh, they're following me in the car right now, but I could totally lose them if you want me to. I'm like, what are you talking about, bro? Like, I don't even know what are we talking about here? What's going on? He's like, hey man, they're and I'm going to apologize in advance about the language. I don't mean to be disrespectful or insulting. I am just merely stating what he told me. This was his statement to me. Hey man, they're a couple of trannies. And I'm like, okay. He's like, yeah, they're like women, but they're not women. They're dudes. And I'm like, okay, like, what's the problem? Can they play this game? And he's like, well, yeah. I mean, they called me to play the game. I'm like, okay, well then, how about this? How about we play the game? And if we have fun, great. And if we don't, well, then we call it a night. He's like, all right, man, all right, cool. So he shows up, and these two male to female trans persons come in with him. One of them is very passing, and the other one is completely not passing at all. Very not passing. The opposite of passing. So anyway, like, you know, we're gonna get the game together. We're gonna go over thing and figure it out. Everybody's gonna get their little thingy set up and everything like that. So so I'm like, okay, you know, like, we'll call my buddy Dave. His name might even be Dave. We'll call him Dave though, for the sake of the argument. And I'm like, okay, so Dave, you help one out, and I'll help one out, and everything will be cool. So he's like, okay, yeah. And to the passing was like, yeah, you sit next to me and I'll help you out. And so we start getting them all set up so that we can play this game because they haven't played it before or whatever. And then, you know, I get done helping my player out first. I'm going to call her my player. And then I'm like, okay, you know, like, you know, you're having trouble over there. I'm a little bit more familiar with the rules and everything than you are. How about we like switch, and I'll help your player out. I'll help her out. And she starts getting up, and he grabs her. He's like, no, you're sitting by me. This total transphobe dude is like desperate to have the passing with it. I made fun of him about him for that for years. This guy, like, you remember that time you fought over a trans woman? Oh my god. I'm sorry. I'm so sorry. That was some funny times. He never lived that one down. No one don't know what happened to him. He started doing drugs and he's gone now. Don't know where. Anyway, we were talking about excusable error by plaintiff. Plaintiff claims that he should be able to amend. He fails to grasp that he amended. He omitted stuff when he did amend it. He can't rely on his pro se status to claim an excusable error when he originally named them and then stripped them out. Conclusion, plaintiff's motion reconsiders merely re-arguing issues that have already been ruled upon. That is clear. Plaintiff's aforesaid motion fails to set forth a clear error of law, newly discovered evidence, an intervening change in controlling law, and or a manifest injustice that warrants reconsideration. That is the standard that he needed to plead, and he didn't do it. So they request that it get denied. So that's that. And then we have a last, and I certainly hope the least. I already did this one. I thought there was. Another one. Oh, Jesus. There's a bunch of them. Did I already do this one? Let's see. I did that one already. That was the response to the motion for sanctions. I must have done these. Did I do this one? I did that one. Here we go. All right. Are these the same? Yeah, they're the same. All right. So he's filed a motion to extend time to respond to the motion, or the alternative, leave to file late reply, a motion to extend the page limit for the reply. So Wallace moves the court for an extension of time to reply to LVMPD's frivolous response to the motion to reply, or an alternative, leave to file a late reply in the interest of justice. Motion is made and based on the attached memorandum of points and authorities, pleadings, and papers on file herein. Any oral arguments are allowed. I don't think anybody asked for oral argument. You actually have to ask for oral argument up here in the caption. So I don't think we need to be confused about my sexuality anymore. I'm upfront about my sexuality. I'm Californian. That's my sexuality. When emailing only the currently participating defendants, i.e. not Nevada. Nevada still hasn't made an appearance or anything in this, so I'm wondering what's going to happen there. They did not oppose my motion to stay proceedings while I could find counsel. I haven't found counsel. Additionally, LVMPD has improperly submitted lots of evidence in the response. It will take me a while to comb through and object to, and they continue to misconstrue facts. It requires me to correct just about every, quote, fact that they have newly alleged or, quote, referenced. Why are we borking? No borking. Additionally, since I am currently traveling, I won't even receive the thumb drive they attached, assuming they mailed it to me, until after 7 days. My wife is currently, we've got some barn cats. We just got 3 barn cats today. We have ground squirrels that are just doing a lot of damage. And the previous owners of this place had barn cats, and the barn cats kept the ground squirrel population under control. And so I'm not really a huge cat guy, but I mean, cats are whatever. I'll pet the kitty cat or whatever, but I don't want to own one particularly. But we ended up getting 3 feral barn cats, and so she's checking them out. We're keeping them locked up in a garden shed for a few days to make sure that they figure out that this is home. Stay home. This is your home. And hopefully they won't run off or get eaten by hawks or whatever until they get accustomed to the place and big enough to kill and eat ground squirrels. Finally, LVMPD will need at least 21 days to withdraw their response for a safe harbor period while I notify them of additional sanctions motions. So again, I think he's misconstruing the required procedure. He's supposed to serve on them a copy of the motion he is going to file. He's going to say, here's a copy of the motion that I'm going to file in 21 days if you don't withdraw your motion or whatever. And then in 21 days, he then files the specific motion that he served on them 21 days ago. That's the way it's supposed to work. Now, his sanctions motion. Hey. No. Siobhan is not happy with cats. Boy, that's going to be fun. That's going to be fun. So his motion for sanctions is doomed from the start, but I'm sure he's scaring the attorney with threat of sanctions. Oh no, not a sanctions motion when I haven't done anything sanctionable. Since LVMPD's response is 11 pages long, if I'm going to quote each fallacy, like this is a fucking logic paper, he's going to quote fallacies, idiot, when responding to each one to object to all the improper, quote, evidence and add some legal argument. My reply is expected to be 22 pages long. You know, she never said this, but it's not the length that matters. All right. It's the quality of the argument. Because she always says length matters. I mean, that's don't believe anyone who tells you length doesn't matter, except for legal documents. Length doesn't matter in a legal document. That's for sure. It's the quality of the argument. Memorandum points and authorities. The court can extend time, sure. Discretion to file, to accept late filings, sure. Local Rule 7.3 allows a party to request leave to exceed the 12-page limit for replies, sure. Misconstrued facts, like, I don't think so. You don't have to quote what they said and they say what it really is. Just state your facts. You can do it in 12 pages or less. It has forced me to provide lengthy quotations and corrections requiring more than 12 pages to respond. LVMPD also attempts to incorrectly submit a lot of documentary evidence that needs to be objected to. So he respectfully, I don't know if Chili knows what the word respectfully means, request court extend the time to file a reply until September 25th or longer, or in the alternative, leave to file a late opposition, and to file a 22-page reply. A 22-page reply. That's some bullshit there. All right, so we are done with this bullcrap, and we're going to go through the comments. I have about 2 hours of NTFG stream that I would like to get through tonight, so don't expect me to waste all night playing with you kids. And once again, I'm going to be on NTFG, Coded's NTFG-SFW channel. Subscriptions, NTFG. We're going to grab this, copy. We're going to paste. We're going to boop. I just posted a link to Coded's NTFG-SFW channel. I'm going to have a discussion with him. It's not going to be a debate. I've learned after talking to people like Stout that if you accept the debate from a shithead on the internet, they're going to change the terms before you get there. And not have enough brain cells to put together to actually talk to you about the subject that they thought they were going to talk to you about. So it's just going to be a discussion, and I'm going to educate him on why self-censorship And I use those words very specifically, self-censorship. And I have meanings for both of them. Why self-censorship is the worst form of censorship. So, Uriel Gray was first in today. Hi, hope you're doing awesome. If you were doing me, it would be awesome. Hi, Zenowin. Howdy, Salty Explorer. Have you explored all the salt yet? Or are you the salty one exploring? Chili at it again? Oh, Cobra. It's not just chili. There's plenty of other fish in the sea. Hey, happy Friday, Kim Workin. I'm pointing. Nasty Nathaniel, you are a fascinating man. We should go to the grub steak sometime. NTFG. Hello, Merbeast John. Donate to my G-String account. Very much appreciated. Bow chicka wow wow. Shiz Isle. He got so horny, he couldn't even type right. Hi, Michelle. Schiff, I love you. NTFG. Babyface Merb. Merb has a younger brother. No, he doesn't. Holy no beard. I know. I existed most of my life without a beard. Isn't that fascinating? I think that's fascinating. I'm fascinated by how fascinating that is. I've only had this beard for about a year. You bastard. You are my only link between me and Shiz's pants. And you've ruined that. I'm sure, if that fat fuck from Ireland could woo her, all you need is a good filter, bro. You're in there. Get a good filter. You're in there. Go back to the pic. I wasn't finished yet. Fucking baiter. It was so sexy I couldn't look away. I know. I've had that happen to me all my life. Low, low. Low, low. Low, low. Low, 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 low. I'm not aware of too many things, but I know what I know, if you know what I mean. I got you to play Dicta. Nice. Nearly tailored like Merb's G-string. You got it. Only the finest, most tailored G-strings for me. Welcome back, Seafool. Missed your broadcasts. I got you to say Dicta. Oh, you got me to day Dicta, and then you got me to say Dicta. Whew. I wonder what you're doing with your Dicta. Are you typing with one hand, brah? Kissy face back at you, Denise. Hey, everyone, says Floby. Hello, Denise Lynn. How you feeling? I'll bet she feels pretty good. You want to feel her? Y'all got any of that PayPal? What's up, Not News Patrick? Oh my God, the thumbnail had no beard and it scared me. The beard is part of your shtick. You know what's part of my shtick? My shtick is part of my shtick. Dan? Hi, Alan. I'm still kicking. Thanks for asking. Oh, the funniest fucking thing ever was Denise Lynn was fucking around with a what do they call those? It's not like a taser, but it's like a shocker. It's got the two little prongs on it. You have to stick it up against someone and push the button. She was sitting in a fucking hotel room or something, and she was fucking around. She put it up to her leg and zapped herself. Oh, that was fucking hilarious. That was fucking hilarious. It just makes you wonder, like, what were you thinking was going to happen? What were you thinking? Next time, stick it to your tongue and do it. Hello, Nathan. Hello, friend. Yes. Stout, and stout. Pro se litigants. Merb will join me at NTFG-SFW Saturday evening for cocktails and cunnilingus. Cunning linguists. Cunning linguists. Not cunnilingus. Cunning linguists. Yes. Hi, coded friend. Green heart. Wavy hand. Digitally. What time? Hello, Flo B. Oh, man. Lol, enjoy the adult date. Is there any other kind? Because, I mean, if it's not an adult date, then that's illegal. We don't do that. Nice. What time Saturday? 0 p.m. my time. 6 p.m. Merb's time. 9 p.m. my time. I think that is I think there's a bit of an error in your story there, buddy. I think your facts aren't straight. I think we need to see the receipts on these PMs. East Coast versus West Coast. Thumbs up. Thumbs up your butt. Be there or be square. Well, I'm kind of round because round is a shape and I'm in shape. Jed and Kerr. Jadon. Merb, please bring your own hand warmers. Cold hands, warm heart. I can turn my camera on, but then I'm only filming from the waist down. I turn my camera on just by looking so handsome in front of it. Calm your pants, boy. We don't need that. The ladies might like it, though. I do like the ladies. Excitable boy, they all say. Howdy, cowboy, everyone, and Merb. Wavy hand, wavy hand. Merb is showing his age. Smile. Just got here. Which ones has he gone over? Yes. Is this how you prepare? Prepare. I don't prepare. I don't prepare at all. It's 3 pumps and a dump. Why prepare? Rocky Horror Picture Show. I always dressed up as Magenta to hit the midnight show Rocky Horror. Kinky elbow sex. Yes, please. Overturn Turner versus Driver. Red Heart. Merb, you are the devil. I fully intend to help supply you with various G-string styles. Now I must bleach my eyes. Your donation? Thank you. Thank you. There's starving children in Africa who are thanking you right now because you have gifted them so much joy. Turner versus Richard has been covered. Let's do the time warp again. Loved it, says Denise. I lost my virginity at 14 in 1980 with Rocky Horror. That's terrible, and I'm sorry to hear that, because people should not be denied their childhood by having sex at too young of an age. Same. Rarely miss a chance to go in high school and college. Nice. Chili's LVMPD trial, September 12th. On our Nevada judges, hot buttered popcorn and cold beer optional. Well, that will be interesting. He's actually going to trial. Well, that's really fucking stupid of him. So let's see how it goes. I don't think he's got a good chance, but maybe. Juries are a funny thing. Does he even qualify for a jury trial? It might be a bench trial. He might only get a bench trial. I don't think a judge is gonna play the old Chili game. That was probably not a smart move by old Chili con carne. Flo B says hi at Laura Rayner. Wavy hand, green heart. Alan, I have some medical brownies. Flo B says sorry, Alan Killian. Forgot to say hi. Hi. Wavy hand, green heart. Laura Rader says, hey, Flo B. Red heart with a little gleam to it. Don't mean to be slow. Just finished dinner and about to start cleaning up. Alan Killian says, Flo B. Hello. Laura Rader says, but maybe worth a short break for Pantsless Merb. It's always just a short break with Pantsless Merb. I ain't got no staying power. That's donate to my G-string account. Denise Lynn says, show your love and hit Merb's like. Thumbs up your butt. Coded Friend says, lol, wow, I was so wrong. Exclamation mark, exclamation mark. Yes, you were so wrong, Coded Friend 001, in so many ways. Because self-censorship is the worst form of censorship. Jerry Farrell Jr., I almost said Jerry Falwell, says, I want to see you in a G-string. You got to buy me dinner first. Oof, says Pure Fetish. That one's better than the last one. To you too. Caphalia says, not even a $4 bottle of scotch? Well, I mean, if that's what you're bringing, then I'll drink it. Sure, why the hell not? Coded Friend says, it's an impressive account. A bit smaller than I thought it would be. That's what she said. We have these really large moths that act like hummingbirds. They really fast, and they're giant. And one of them just almost flew into the camera. You might have seen it. You might not have. WTT, my boy, says, were you waiting on the original complaint turn review driver? I was, and you came through. You're the best. GMK Esquire says, Jesus fuck. I should have known better than to hit that link. What do you mean? Are you not a giving person? Did you not like the free gift I gave you just for hitting the link? Is this how you express your thanks? You're not a very nice person. You're not a very nice person. Denise Lynn, always a gracious person, says, but green's not your color, Merb. Well, I think it is. Actually, my mom says that I look best in green. She likes me in a nice green. It brings out the blue in my eyes. For some reason, I look better in green than blue. Coded Friend says, I made a double donation to make up for my error. Well, wipe up the mess, sir. Wipe up the mess. It's in my Discord. Again, you're the man. GMK says, I donated? Well, did you or didn't you? The question marks lead me to believe you might be lying. Denise Lynn says, lol, I like purple more. Oh, Pure Fetish says, lol, I like purple more. Jerry Farrell says, do you have any dick pics? And again, only yours, sir. Darkly Noon says, lol. Denise Lynn says, lol. WTT says, I should have just uploaded a PDF of Goatsy. I appreciate you not doing that, WTT. I strongly thank you from the bottom of my heart for not doing that. I really appreciate it. GMK says, I feel violated. Jesus fuck. Well, why are you having all the fun over there? Why can't someone be over here violating me? I mean, what am I, chopped liver? Coded Friend says, can you donate to G-String account for others? I might have to make a donation for Dildan. I hear his wallet is empty, just like his brain. Pure Fetish says, WTT, shh, it's better to ask for forgiveness than permission. That is technically true. I still don't want Goatsy. No Goatsy, please, on my Discord. Please, please. Pure Fetish says, Denise Lynn, purple and that beard? Perfect. Thank you. I am perfect. Jeff says there must be a stripper named Pacer. We've been through this. Don't blow my cover, sir. GMK says, can I just leave? Absolutely. Pure Fetish says, at least Denise Lynn. Lol. Denise Lynn says, I call for animal print for that G-string for Merb. I would look good. A little, what do you think? A little zebra stripes or leopard print? Snake skin. That's, yeah, boy. Pure Fetish says, at GMK Esquire, who's going to feed and cook the chickens? You can't have your pudding if you don't eat your meat. That is a good point. Coded Friend says her. Coded Friend has a difficult telling male to female, female to male. I mean, it's just, he's admitted to it. He's working on it. He's already been through the struggle session and he's come out on the other side. Papa Sanzer says, I hope your week went well, Merb. You know what? My week did go pretty well. Got a $15K check. That's pretty good for a settlement. It was a pretty good week. Very happy. I'm so confused, says Coded Friend. Well, you'll figure your sexuality out someday, sir. Coded Friend asks, what are her pronouns? Well, you've just used her pronouns, sir. Her is a pronoun. You've already used it. Laura Raider says, red heart with bling, red heart with bling, red heart with bling. Can I bounce on your lap too? I will assume that you're talking to me, and I will say yes. You certainly can. Let me clean out a spot for you. Laura Raider says, I love stories and detours. Well, you got one tonight. Denise Lynn says, Coded is so Merb's wife. How did you figure it out? I thought we were being sly, but can't sneak anything past Denise Lynn. The jolt from that shocker, just it activated her brain. She's like a superhero now. Those synapses just firing left, right, and center, boy. Woo! Pure Fetish says, I've always wondered that. Female to male, do they use a donated unit? How does it work? Well, if they have the bottom surgery, I believe what they do is they cut off some of the tissue, the skin and some of the tissue from like this section of the forearm. And they use that to form the unit. And I believe they take, I'm not really familiar on all of how they do it, but I think they take the clitoris and kind of move it to the end so you have some sensory out there. And I think they use like a pump device to, but I could be wrong. It's, you know, I generally don't approve of that kind of thing, though, just because I think it's very destructive. And you know, I've seen like the after effects of it, especially like it doesn't look, I mean, it doesn't grow back. I mean, they take actual tissue. It's not just a skin graft where they take a top layer of skin. They take the skin, like it's very noticeable. It's like a burn victim, kind of like where things are gone. Like it's not good. Yeah. And I don't know all what goes on down there, but I've seen TikTok videos where people are regretting various things like that. And permanent. It's real permanent. It's not like you could just undo it real easily or anything like that. So, you know, I'm not a big fan of body modifications where it's gonna take away your ability to reproduce, because that's like, it seems like as a biological organism, that's our ultimate driving goal. I mean, generally speaking, hashtag not all, but the rule is that's like what people want. And yeah. Code of Friend says, fuck yeah, it's mind-blowing, even boggling. GMK Esquire says, pure fetish is the pudding made with cream. Pudding is, I believe, like a pastry, like a meat pastry, isn't it? Darcy says, I only saw a photo. It was awful. Did not see a donate button. Got to look close. Got to look real close. Study it. Let it burn into your mind. You'll find it. I promise you. Denise, Coded Friend says, Denise Lynn, the wife must be very understanding and tolerant. She's a saint. She's a goddamn saint. Pure Fetish says, at GMK Esquire, only if you work on the meat enough. That's true. Coded Friend 001 says, at Darcy, hover over the obvious to get the donate button. Keep trying. You'll get there. Denise Lynn says, at Coded, Merb would need no less. That is true. Coded Friend 001 says, is there any crying in the, quote, game, end quote? And then Loretta says, Lola, la 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 Lola. Pure Fetish says, those who know face purple crying, those who know cat orange whistling. Darcy says, thanks, Coded Friend. Coded Friend says, Laura, just like the cherry cola. Laura says, there's no crying in baseball. Tom Hanks in that girly movie. Laura Rader says, laughing, Coded, yes. Darkly Noon says, Lola looks like a woman but talks like a man. Laura Rader says, laughing, crying. Pure Fetish says, Laura Rader, there is if a ball goes astray into a unit or into a bystander. Denise Lynn says, someone refill Merb's bourbon. No, I'm only going to have the one tonight. We'll be fine. We've got a lot to do tomorrow. We're not getting drunk tonight, kids. Laura Rader says, Merby. We're on that kind of level now. We're close friends, so she can call me Merby, and I call her Lori. Merby's laughing is contagious. I lost the plot, but I can't stop giggling now. Thanks for the detour, Merb, says Coded Friend. Drunk Rob TDB, Coded Friend, do you feel professionally threatened by self-parking vehicles? Throwing shade. The man just spent like over 10 grand on a family vacation where he spent 13 days in Hong Kong. When you spend 13 days in Hong Kong with your family, you let me know. And then we'll talk to you about how you feel about self-parking vehicles. Pure Fetish says his detours are the best. Lol. You must have been in bed with me at one point in time or another. GMK Esquire says, passing, end quote. On the left, if possible. Laura Rader says, at Pure Pure Fetish, baseball fans should man up and players should use a cup. Yes. It wasn't Little League. What is it? Was freshman, not junior varsity. The coach would make us all open up our legs and cup check us. Never got to play. Had to start working. So anyway, when they're going down the line, we ding, 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 just to make sure you had a cup. This is a long time ago, obviously. If you didn't have a cup, he knew about it before it got to you because they bounce up quick. I mean, they see it coming. Oh, no, I forgot my cup, coach. Code of Friend says, at Drunk Rob TDB, I do work for a company that provides valet services. And apparently a good enough paycheck that you can afford to go to Hong Kong with your family and stay there for like 13 days. Chris H says, hello, ladies and gents. Rock out with your cock out and jam out with your clam out. That's how babies are made. Drunk Rob TDB says, is that a yes or a no? Because he doesn't realize that he's the butt of the joke. Laura Rader says, lol-cow motions tend to run together. They sure as shit do. Laura Rader says, oh, Cam. Oh, Cam. Pure Pure Fetish says, at Laura Rader, if I get a 10-mile-an-hour baseball to the face, I'm going to cry my ass off and probably go to the ER. So, there's this little Asian kid. I want to say his name was Jimmy. His name was Jimmy. I don't know if I think that was his anglicized name. I don't know if that was his like legit birth name. Because he was from Korea. Anyway, I played catcher, and at lunchtime, we would go out onto the baseball diamond, and the one that was nearest to the gym, and he wanted to pitch, and the kid could throw a fastball, but he could only throw a fastball, and so he'd pitch, and I'd catch, and he really wanted to get good enough that he could actually, maybe get like a scholarship or something for baseball. Anyway, all he could throw was a fastball, and he was short. So, I mean, usually it's tall guys who do well. And maybe the game has changed, but when I was young and I still gave a shit about sports ball, it was the tall guys who usually could do the best because the long arm, the leverage, whatever. I don't know. Anyway, this was a long fucking time ago. Like this was back in the late 80s. He brought a baseball to school that had a little digital clock readout on it. And you hold a button and you keep it depressed. And then when you threw it, obviously it would release the button, and then the impact onto the mitt would have it stop. And it would tell you how many miles per hour it threw. Like as long as you threw it from the correct distance, like from the pitcher's mound, like as long as you threw it from the correct distance, it would do the math or whatever, and it would figure out how many miles per hour you threw the ball. And he brought this, and he's like, okay, like this is relatively delicate. Don't let it hit the backstop. Like, come on, dude. I've been catching for like 2 or 3 months, man. Like, come on, this is me, man. I'm pretty good at this, right? I'm pretty good at this. And the kid can only throw fastballs. Only throw fastballs. So we're throwing. He's getting warmed up. He's getting loose. He's throwing it. And then, as he gets loose, he starts putting a little more heat on it because he really wants to be somebody, right? Anyway, he winds up the last one. He winds up and he throws it. And it was like in movies, things go slow motion. This went slow motion. I saw it coming at me. It was coming at me, and all of a sudden it just started dropping. And it was a late drop. Like, I mean, I could catch sinker. I'd catch curveball, I catch sinker, whatever. So not a big deal because I was good at it. I kept my eyes open. I didn't blink. I catch the fucking ball, right? Anyway, it's this late breaking sinker, and the kid doesn't throw a sinker. I'm not ready for this. I'm not ready for it. And I'm like, no, and I'm trying to drop the glove down to catch it. Slow motion. Smack right into the nuts. And, the way you're sitting as a catcher, like they're cupped up in front. And this was at lunch. I'm not wearing anything. I'm not wearing a cup. I had a pair of jeans on, and this is the late 80s. They were Guess. They were tight Guess jeans. Or were they Jordache? They were tight, whatever they were, because that was what you wore. Don't judge me. So they're cupped right up there, and it was just nutsack bone. Oh, I crawled across there was a section of blacktop that separated the baseball diamond from the gym. It had like a basketball court or something on it. I crawled across that, up the steps into the gym, into the men's room, boys' room, I guess technically. And I pulled my pants down. I'm just laying there. I'm ruined. Pull my pants out just so I could lay there and let my balls like fall down onto the cold tile floor. Oh my God. I thought something was going to be broken, but apparently no harm done. Thank God it didn't hit my head. It broke. It said 88, but I think it was just broken. But the readout said 88 miles per hour, and it never worked again. But because it was one of those digital readouts, it was just broke because my pelvis was hard enough that bam, it broke it. Oh shit. Good times. Anyway, Jimmy was really pissed at me because that was a lot of money for one of those balls back then. He didn't care about my balls. Oops. Jamie says, isn't it true that the Supreme Court shot down Roe versus Wade by essentially arguing there's no right to privacy stated in the Constitution? Kind of. So it was a substantive due process right. So you have a right to privacy in your person effects papers. You do have that right. But the thing is that they extrapolated from that right another right that didn't exist, and they do that. The Supreme Court has done that. There was a very activist Supreme Court, and they were finding all sorts of rights that weren't specifically enumerated in the Constitution, and the basically the right to have an abortion. The woman's interest in having an abortion versus the state's interest in the life of the child was a balancing act in Roe versus Wade. Roe versus Wade was actually not overturned, but basically altered fairly quickly after it came out. I want to say Casey. There was another case, but anyway. So the Supreme Court actually didn't overturn it. Overturned a line of cases that started with Roe versus Wade. But it was a substantive due process right that the court had originally found the right to privacy arose out of the right to privacy. Laura Rader says, shit, lol. Laura Rader says, having a malfunction. Well, I'm sorry to hear that. Sane Rose says, is this the Floyd filing that he magically filed electronically while in jail? Doesn't really matter. Code friend says, add drunk Rob TDB ... I do ... usually indicates an affirmation, i.e. a yes. I do usually indicates an affirmation, i.e. a yes. That's true. I can't tell one stupid locale motion from another one anymore. It gets hard. That's what she said. It gets hard to tell the locale motions apart. Yeah. Drunk Rob TDB says coded a comma would have helped. Coded friend says at Laura Rader, the lines are getting a little blurry. Drunk Rob TDB says without the comma, it sounds like your typical rambling. Someone's a little salty. He's a salty boy. Drunk Rob is a little salty boy. Someone get him a little cup of water so that he could desalinate a little bit. Laura Rader says that pure fetish. ER for sure on that one. My dad was a baseball coach. Did he tap Kids in the nuts with a baseball bat. Bink, bink, bink. Lower Raider says, very blurry indeed. Caphalia says, that's why it's confusing, Burb. There's a lot of reasons why it's confusing. Lower Raider says, oopsie, time to load a bowl of weed and relax. Burb. Well, I hope you do relax, Laura. Coded Friend says, drunk Rob TDB, I'm anti-punctuation. Nice. And you did it with only one bit of punctuation there, the hyphen. Nice. Caphalia says, chicken has a sore throat. Well, I'm sorry to hear that. You should not choke it as much. Sane Rose says, it also doesn't help that Floyd is in jail in Oklahoma as well. That probably doesn't help. Coded Friend says, at Drunk Rob, thanks. Oh, look at all that. Look at all those ellipses. That's punctuation, my friend. Thanks. Dimwits usually mistake intellect for rambling. Have another sausage in a blanket if you're hungry. I do love pigs in a blanket. Delicious. Drunk Rob says, neat. Thank you for participating in my survey. That wasn't very funny, Drunk Rob. Laura says, we always had feral barn cats growing up, kept the rodent population from stealing the chicken feed. Slowed them from it, didn't prevent it. Kay Jamie says the director of a documentary called Chasing Amy is a trans man whose former girlfriend, a lesbian, is now engaged to him. Tell those guys that to blow their minds more. I've seen relationships where a male to female trans will marry a female to male trans, and then they'll have a baby, and it's just like, well, I don't really fucking care, but some people are like, oh my God. And I mean, like, at that point, whatever, bro. Mechanic says, FYC. Biff Thunder Muffin says, howdy. Howdy back to you, Biff. Denise Lynn says, you need barn cats to keep the rats, with a little rat emoji, away. And then the mice will play. Laura Raider says, hashtag FYM, eh? Coded Friend says, at Biff Thunder Muffin, what up? Laura Raider says, dogs may not like the barn cats. We've got shot callers. They will learn to tolerate them. Biff Thunder Muffin says, hey, Coded, still on vacation, you? Coded Friend says, hashtag FYM. Coded Friend says, back in the USA. Back in the USSR. Laura Raider says, girth and gyration skills count mightily, though. Well, you know, I mean, they all add into the general equation, but length is king. And we all know that. Everybody likes a nice long hot dog. You don't want the hot dog not to hit the ends of the bun. You want the hot dog to at least hit the ends of the bun, if not past the ends of the bun. If you have a thick hot dog, but it's like really tiny, then you have all this bread at the ends, that's not doing anybody any good. You got to have a long hot dog. Mandatory. Biff says, nice, Coded. Glad you back. Glad you back. Coded says, enjoy the remainder of your vacation. Idle time. That is the link to tomorrow, where I'm going to be talking to Coded. Biff says, heck yeah. Coded says, Merb, you can suggest an opening tune if you like. I don't know any tunes. I'm sorry. I really like Fats Waller. There you go. Fats Waller. You pick one. I like Fats Waller. Laura Raider says, laughing emoji, laughing emoji, laughing emoji, laughing emoji. I still remember Merp giggling his ass off during this stout debate. That dude, he was so unintentionally funny. And if you don't know the law, if you don't know why what he's talking about is so fucking hilarious, you probably don't get the joke. But it was fucking hilarious. Like the shit he was saying with such confidence. He was so confidently wrong. Fucking hilarious. Uriel Gray says, lol, thanks, Merp. Thank you, Uriel Gray. Code Friend says, Laura Raider, calling Merb's Giggle Fest with Stout made me chuckle. Laura says, laughing. I like Merb in this mood. Not nearly as cranky as chili-related emotions usually make him. It's a good day. 15 grand. That's a good day. Is Merb going to cover the case of Finders versus Keepers tonight? I already covered the case of Nope. In re the matter of Nope. Laura Raider says, tunes, and then whatever the fuck that is. Stop copying my tunes, Merv. I will attempt to stop. Code Friend says, that fat fuck from Ireland. I'm retyping it so Dildan and the snooze can screenshot and run off to Tubby to snitch. He's so fat, it ate his nose. Like the fat came out so far in his face that it ate his nose. That's fucking fat. Shut it, Merv. Are you mad about the Zapper? That's fucking hilarious. That was fucking hilarious. It was fucking hella funny when she sacked herself. Like, what were you thinking? What happened? Oh, shit. Cattle prong. So, last line first. How effed is Chilito? I don't know. He's the normal chili. Lol at Michelle. Chilito will be just fine as long as supporters keep sending him money. Yeah. I mean, he might catch that. He might get a guilty on that misdemeanor, but whatever. Cattle prod. Hey, y'all. Hello, baby. Hello, baby. Hi, Lord Raider. Hand pink waving. Hand pink waving. Vixter says, hello, Merb and chat. Lord Raider says, hand pink waving. Hand pink waving. Vixter says, I'm an hour late. What did I miss? Well, let me just go back to the beginning of the entire stream. We'll just start all over again. Lynn says, Mom is always right. But is she, though? Denise Lynn says, Moms are always right. This is about the green. Oh, I'm a good-looking son of a bitch in green. I mean, I'm not even going to lie. Zoe Christ says, ask Coded why he wants to burn gays and Jews. Okay. Walter TX says, hi, Merb. Hiya, Walter. The show can get started now because Walter's here. Laura Raider says, Walter, red heart with bling. It's been a fun night with Merb. Denise Lynn says, I needed this night. Thanks, Merb. That's what she said. Matto311 says, catcher. Walter Tech says, hi, Laura Raider. Wavy hand, hug, red heart. I bet it has been. Coded Friend says, at Walter TX, what up, bro? Laura Raider whispers, Walter, I think Merv is about to read my keyboard malfunctions and a series of weird typos. How high were you? Walter TX says, hey, brother, at Coded Friend. Walter TX says, just the weird ones, lol. Laura Raider says, laughing emoji, laughing, crying, laughing, crying. Walter TX does the non-rolly laughing, crying. Laura Raider says, I love slow motion moments. Not when it's baseball headed at your nuts. Walter TX says, ah, ha, 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 ha. Coded Friend says, this fastball story is why Merv doesn't wear pants. It's because my balls are still swollen. Walter TX says, ouch. Ooh, it wasn't ouch. Pure Fetish says, Murphy, sorry to send you on a tangent, but it is quite a story, though. It's a great story to have to talk about what happened in the past. It wasn't great at the time. It was less than great at the time. Walter TX says, you have been doing your pelvic girdle exercises. It was a bone. It was the pelvic bone. That's what broke it. Laura Raider says, thanks. Laughing emoji. Thanks, Pure Fetch, for sending him on this tangent. The balls on the cold tile floor was worth it. Oh, it was worth it. Oh, that was if people were like walking in and stepping over me and stuff, I didn't care. I was like, oh my God, I'm going to die. Oh my God. Because you have that, like, I'm going to throw up. Like, it felt like my intestines were sliding out of my balls. It's a horrible fucking feeling. Yeah, Casey, right? Laura Raider, shh, lol. Walter TX says, balls. Ha ha, laughing, crying. Walter TX says, oh, coaches, there's all kinds of things that would put them in jail these days. I want to go back to a time when people were more innocent, less judgmental. I know. But you know what? No one went out on that field not wearing a cup. No one did. Because bink! No one went out on that field without a cup on. I guarantee that. Walter, the world went to hell and they stopped spanking at home and in schools. Lol, you just like getting spanked, Laura. But I ain't here to king shame. Walter TX is damn right. So I guess Walter likes to get spanked too. How you doing? Denise Lynn says at Laura 100. Walter TX says, when are you going to go back to work again on YouTube? Oh, he streamed last night, bro, or this morning. It was I am a little over 2 hours into it. It was streamed 18 hours ago. Coded stock vacation while I was away. Jason R says, okay, Merb, dogs, please. They're around. There's 3 of them. Sometimes when it's light out, you can probably see them behind me back in there. Hello, baby says, hi, Walter TX. Good to see you. Walter TX says, hi, lovely. Hello, baby. Waving hand, red heart, hug. You can't argue with stupidity, says, darn it, I missed the live. Just woken. Good morning. Well, good morning to you, sir. Hello, baby says, how are you, Walter? Laura Raider says, laughing, crying, laughing, crying, laughing, crying. Sorry, Denise, but that was funny, and I loved having this giggle fest tonight. Walter TX says, okay, hello, baby. Just got a bad diagnosis at the hospital today, though, mesothelioma. Well, I hear there's like attorneys who will happily sue for that, or is it a different one that they'll sue over? I don't do those, but there are some people who do. Is it mesothelioma? It's something like that they sue over. Laura Raider says, hang tough, Walter, with prayer hands, red heart with bling. Sorry to hear that. Me too. Hello, baby says, oh no, dang, now I'm worried about you. Walter TX says, hello, baby. The pulmonologist has to still do a bronchoscopy to make sure. Hello, baby says it's caused by asbestos. Walter says, yeah, I've been around it since high school. Hello, baby says, OMG, Walter. Walter TX says, nope, we didn't. Walter TX says, coded, like to surprise us with the next stream time. Walter TX says, same one. The next stream is going to be tomorrow, 8/26 at 6 p.m. Pacific. Be there or be square. Coded's going to have a very, very handsome guest on. So make sure you don't miss it. That's it for tonight. I've hit the end of the comments. Thank you for watching and have a great day.